Friends, crime is complex. Its dimensions are even more complex. Poverty, neglect, low self-esteem, alcohol, drug abuse, and circumstances into which one is born all influence, and the list can be endless. This Saturday, let's explore some of these aspects around crime and punishment. Friends, if crime is proven, the status changes to that of a criminal. But is there any logic in branding someone a criminal until his crime is proven? Does it justify incarceration as an undertrial? How long can one remain as an undertrial? If he or she is exonerated later, who could possibly restore the lost pride and the lost personality? That it happens in case of more than 67% of 4.33 lakh inmates lodged in 1,400 jails in the country is most unfortunate. They are rarely produced in court, sometimes for want of police escort and scarcely given any legal aid. The National Crime Records Bureau, NCRB, prison statistics a few years ago, released in a couple of years back, further reports that almost 2,000 children have to perforce live in these jails with their mothers who are under trials. Are these children then deductive under trials, or are the children or do they belong to lesser gods? Meaningful incarceration for long periods leaves the prisoners and their families financially and emotionally devastated, and even mars their future chances of employment and societal integration. The periods of incarceration can make psychological wrecks of even the bravest of them. Many of them neither have access to a decent lawyer, nor have any funds to buy coupons for daily items, or grease the palm of prison mates, prison officials, or convict warders to avail better facilities such as mattresses or better ventilated places. Does Article 39A of the Constitution, which provides free legal aid to those who cannot afford it, actually deliver? We have had deep-rooted caste prejudices and lack of opportunities for a decent living in the society. Even over-policing affects the delicate balance between various communities. Add poverty and we have a heady mix of crime both inside and outside the prisons that we have. Prisoners too have fundamental rights under Article 14, 19, 20, 21 and 22 of the Constitution of the country. Whereas Article 14 deals with the right to equality before law and equal protection of law to all persons, Article 21 deals with the right of life and personal liberty. These are, however, seldom practiced. Doesn't an undertrial deserve to be treated fairly? The recent NCB probe has exposed several chinks that need laws not only to be applied equally but also seen to be applied equally. Whereas for similar levels of crime, some escaped with just 3 or 4 days custody, there were others who spent more than 3 months in custody. Yet there are others roaming free. The common thread, however, is that almost all had their cases heard on a weekly basis, without delays. There are instances where the cases of high and mighty are heard with a day's notice in the highest of the courts. There are also those who have absconded for months and years together without a trace, making a comeback at an opportune time. None of them had to face the under-trial ignominy. The wheels of justice indeed move fast when interests of the powerful are involved. Why can't we apply the same standards to the scores of under-trials in the country who otherwise are languishing in the most inhuman conditions without a trial? Yes, the law does protect an individual by way of release on a personal bond under section 436 of the Code of Criminal Procedure for certain classes of crime, if the under trial has already been held for a period equal to half the potential sentence that he may get. But then, how does one estimate what that potential sentence could be when the crime itself is subject to a host of accompanying circumstances, proving the veracity of which can be extremely contentious? That the code is misused more often than not in releasing a large number of under trials incorrectly is probably another major concern. Since the under trials are poor most of the time and cannot afford legal recourse, the state provides them help. However, since these lawyers are paid a pittance, they seldom deliver on merits. The lack of financial resources encourages the rise of middlemen, sometimes the same lawyers who provide sureties at a cost and also get a cut. They have a clientele from the marginalized communities interested in seeking bail. India has one of the lowest police to population ratios in the world, at 1 persons for 1 lakh population. Even the quality of investigation is poor, resulting often in longer incarceration of under trial prisoners. Should we not raise the remuneration for legal aid lawyers, standardized across the country, recruit more of them, along with a separate reserve of police personnel to escort the under trials? If we were to infuse a little sanity in our legal systems. According to the NCRB data, as on March 31st, 2016, 6 years back, more than 3 crore cases are pending in various courts. And 2 out of every 3 prison inmates in the country are under trials. The Supreme Court must be lauded for a very historical judgment in recent times in reference to under trials and inhuman conditions in our prisons. It now requires that there are under trial review committees in every district, which meets every quarter to look into effective implementation of sections 436, 436A of the Criminal Procedure Code, so that under trial prisoners are released at the earliest, including those who cannot furnish bail bonds due to poverty. Among many other facilitating reforms, the Secretary of the District Legal Services Committee is to look into the issue of release of under trials prisoners in compoundable offences. He must explore the possibility of compounding offences rather than requiring a trial to take place, establish fast-track courts, establish open prisons in states and undertakings, launch a national mission for justice delivery and legal reforms, introduce the concept of plea bargaining through section 265 of the Criminal Procedure Code. Even insertion of section 436A setting a limit for the maximum period for which an under trial prisoner can be detained, promotion of plea bargaining by National Legal Services Authority within the Criminal Procedure Code parameters and providing free legal service are all excellent reforms by the Supreme Court. Friends, having put in motion an enabling system, the next step must be to implement the provisions in earnest by both the state and the center. For the undertrials too are citizens of the country and not criminals till their crime is proven. If not treated fairly, their paranoia, disgust, guilt and horror can turn them to more crime. Our society can be better off without it. Hoping that you are wiser on the subject, let me conclude with a promise to be back again the next Saturday. Until then, thank you, namaskar and dhanyavad.